Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Culley v. Marshall. In this case, the court considered this issue. What test must a district court apply when determining whether and when a post-deprivation hearing is required under the Due Process Clause? The case was decided on May 9, 2024. The Supreme Court held that in civil forfeiture cases involving personal property, the Due Process Clause requires a timely forfeiture hearing, but does not require a separate preliminary hearing. Justice Brett Kavanaugh authored the 6-3 majority opinion of the court. The Due Process Clause of the 14th Amendment generally requires notice and a hearing before the government seizes property. However, the court's precedents differentiate between real property, which can be neither moved nor concealed, personal property risks being removed, destroyed, or concealed before a civil forfeiture hearing. Thus, as the court recognized in United States v. $8,850 and United States v. von Neumann, a timely post-seizure forfeiture hearing provides the constitutionally required process after seizing personal property. For such personal property, a separate preliminary hearing before the forfeiture hearing is not required. In contrast, in United States v. James Daniel Good real property, the court held that the government must ordinarily provide notice and a hearing before seizing real property that is subject to civil forfeiture. Here, the property subject to forfeiture is a vehicle, personal property, so a timely post-seizure forfeiture hearing is all the Due Process Clause requires. Justice Neil Gorsuch authored a concurring opinion, in which Justice Clarence Thomas joined, agreeing in large part with the majority's reasoning and conclusions, but writing separately to highlight some of the many larger questions this decision leaves unresolved about whether, and to what extent, contemporary civil forfeiture practices can be squared with the Constitution's promise of due process. Justice Sonia Sotomayor authored a dissenting opinion, in which Justices Elena Kagan and Ketanji Brown Jackson joined. Justice Sotomayor argued that the majority's opinion is too broad and prevents lower courts from addressing myriad abuses of the civil forfeiture system. She, on the other hand, would have decided only which due process test governs whether a retention hearing is required, and left it to the lower courts to apply that test to different civil forfeiture schemes. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Kavanaugh delivered the opinion of the court. When police seize and then seek civil forfeiture of a car that was used to commit a drug offense, the Constitution requires a timely forfeiture hearing. The question here is whether the Constitution also requires a separate preliminary hearing to determine whether the police may retain the car pending the forfeiture hearing. This court's precedents establish that the answer is no. The Constitution requires a timely forfeiture hearing. The Constitution does not also require a separate preliminary hearing. Halima Culley loaned her car to her college-aged son. On February 17, 2019, police officers in Satsuma, Alabama stopped the car while the son was driving, and the officers discovered marijuana and a loaded handgun in the car. The officers arrested Culley's son and charged him with possessing marijuana. The officers also seized the car incident to the arrest. At about the same time in 2019, Lena Sutton loaned her car to a friend. On February 21, 2019, police officers in Leesburg, Alabama, stopped the car while Sutton's friend was driving, and the officers discovered a large amount of methamphetamine in the car. The officers arrested Sutton's friend and charged him with trafficking methamphetamine and possessing drug paraphernalia. The officers also seized the car incident to the arrest. At the time of the seizures of the two cars, Alabama law authorized the civil forfeiture of a car used to commit or facilitate a drug crime. Officers could seize the car incident to an arrest so long as the state then promptly initiated a forfeiture case. In the interim before the forfeiture hearing, the car's owner could recover it by posting bond at double the car's value. At the forfeiture hearing, the owner could prevail and recover the car under Alabama's affirmative defense for innocent owners of property subject to forfeiture. That defense required the owner to show that the owner lacked knowledge of the car's connection to the drug crime. The state of Alabama filed a forfeiture complaint against Culley's car on February 27, 2019, just 10 days after the seizure of the car. But Culley waited 6 months before answering that complaint, and she waited another year, until September 21, 2020, before raising an innocent owner defense in a motion for summary judgment. Soon thereafter, on October 30, 2020, an Alabama state court granted Culley's motion and ordered the return of her car. Sutton similarly moved slowly in her forfeiture proceeding. Alabama brought a forfeiture case against Sutton's car on March 6, 2019, just 13 days after the seizure of the car. Sutton initially failed to appear in the case, causing the state court to enter a default judgment for Alabama. Sutton later requested that the state court set aside that judgment, and the state court did so. Sutton then submitted a brief answer and served discovery requests on Alabama, but Sutton otherwise took no action until the state court set a date for the forfeiture trial. On April 10, 2020, 3 weeks before the scheduled trial date, Sutton finally moved for summary judgment on the ground that she was an innocent owner. Soon thereafter, on May 28, 2020, The state court granted her motion and she recovered her car. While those forfeiture cases were ongoing, Culley and Sutton filed purported class action complaints in federal court. Culley sued in the U.S. District Court for the Southern District of Alabama. Sutton sued in the U.S. District Court for the Northern District of Alabama. Both sought money damages under 42 U.S.C. Section 1983, claiming that the state officials violated their due process rights by retaining their cars during the forfeiture process without holding preliminary hearings. Culley and Sutton argued that a preliminary hearing, also referred to as a retention hearing, is required under the Matthews v. Eldridge due process test, which balances the private interests at stake, the value of added procedures, and the burdens on the government from the added procedures. The District Court for the Southern District of Alabama dismissed Culley's complaint, relying on this court's decisions in United States v. $8,850 and United States v. von Neumann. The District Court held that due process requires a timely forfeiture hearing but not a separate preliminary hearing. The District Court then assessed the timeliness of Culley's forfeiture hearing under the four-factor test set forth in $8,850, which looks to I. The length of the delay of the forfeiture hearing, 2. The reason for the delay, 3. Whether the claimant requested a timely hearing, and 4. Whether the delay was prejudicial. The District Court concluded that Culley's forfeiture hearing was timely under those factors because she played a significant role in delaying her own case. The District Court for the Northern District of Alabama similarly entered summary judgment against Sutton on her due process claim. The District Court determined that Sutton's claim depended on whether she received a timely forfeiture hearing within the meaning of $8,850. The District Court ruled that Sutton's forfeiture hearing was timely and satisfied due process, in part because Sutton never asked for an earlier hearing. The U.S. Court of Appeals for the 11th Circuit consolidated the two cases and affirmed. The Court of Appeals rested its conclusion on circuit precedent, which in turn relied on this court's decisions in $8,850 and von Neumann. Because of a conflict in the courts of appeals over whether the Constitution requires a preliminary hearing in civil forfeiture cases, this court granted certiorari. Under the Due Process Clause of the 14th Amendment as interpreted by this court, states ordinarily may not seize real property before providing notice and a hearing, but states may immediately seize personal property, such as a car, that is subject to civil forfeiture when the property otherwise could be removed, destroyed, or concealed before a forfeiture hearing. When states seize and seek civil forfeiture of personal property, due process requires a timely post-seizure forfeiture hearing. In this case, petitioners Culley and Sutton do not challenge the timeliness of their forfeiture hearings. Rather, they argue that the Due Process Clause requires states to also hold a separate preliminary hearing before the forfeiture hearing. Culley and Sutton argue that a preliminary hearing is constitutionally necessary to determine whether states may retain seized personal property, pending the ultimate forfeiture hearing. As petitioners envision it, the preliminary hearing would focus on the probable validity of the forfeiture. The preliminary hearing would be adversarial. The parties could introduce evidence and cross-examine witnesses, and property owners could raise affirmative defenses, including innocent ownership. In essence, the preliminary hearing would be an earlier version of the forfeiture hearing itself. Alabama and its amici, including the United States, disagree. They argue that a preliminary hearing is not constitutionally required. To begin, they emphasize that most states and the federal government do not currently provide preliminary hearings in civil forfeiture cases, so requiring a preliminary hearing as a matter of constitutional dictate would necessitate a major change in the states and the federal government's long-standing practices. Alabama and its amici also contend that a property owner's post-seizure rights are already protected by the constitutional requirement that the forfeiture hearing be timely. They further assert that requiring a hearing before a hearing in every case, as petitioners want, would interfere with important law enforcement activities that must occur after the seizure and before the forfeiture hearing, including identifying and contacting potential claimants of the property, coordinating forfeiture proceedings with related criminal investigations and prosecutions, and ensuring that property is not removed, destroyed, or put to illegal use before the forfeiture hearing. Ultimately, we need not reweigh the competing due process arguments advanced by the parties because this court's decisions already resolve the issue. After a state seizes and seeks civil forfeiture of personal property, due process requires a timely forfeiture hearing but does not require a separate preliminary hearing. The dispute arose when the Customs Service seized currency from an individual entering the United States, but then waited before filing for civil forfeiture of the currency. The property owner argued that the delay violated due process. This court concluded that a post-seizure delay may become so prolonged that the dispossessed property owner has been deprived of a meaningful hearing at a meaningful time. The court elaborated that timeliness in civil forfeiture cases must be assessed by analogizing to a defendant's right to a speedy trial and considering four factors: the length of the delay, the reason for the delay, whether the property owner asserted his rights, and whether the delay was prejudicial. Those factors are appropriate guides in the civil forfeiture context because they ensure that the flexible requirements of due process have been met. In a related case, the court addressed whether a timely forfeiture hearing, without more, provides the process that is due in civil forfeiture cases. The property owner there failed to declare the purchase of his new car upon driving it into the United States. A customs official determined that the car was subject to civil forfeiture and seized it. The plaintiff filed a petition for remission of the forfeiture, in essence, a request under federal law that the federal government exercise its discretion to forgive the forfeiture. The government did not respond to that petition for 36 days. The plaintiff sued, arguing that the government's 36-day delay in answering the remission petition violated due process. The court broadly held that due process did not require a pre-forfeiture hearing remission procedure in the first place. Citing the earlier case, the court ruled that a timely forfeiture proceeding, without more, provides the post-seizure hearing required by due process to protect the plaintiff's property interest in the car. The court explained that the plaintiff's right to a forfeiture proceeding that meets the timeliness test satisfies any due process right with respect to the car. A separate remission hearing is not constitutionally required. This court's decisions resolve this case. As the court stated, a timely forfeiture hearing satisfies any due process right with respect to a car that has been seized for civil forfeiture. The Due Process Clause does not require a separate preliminary hearing. Culley and Sutton's argument for a separate preliminary hearing appears in many respects to be a backdoor argument for a more timely hearing, so that a property owner with a good defense against forfeiture can recover her property more quickly. But the court's precedents already require a timely hearing, and a property owner can of course raise timely hearing arguments in an individual case to ensure a timely hearing. Culley and Sutton, echoed by the dissent here, try to brush aside prior decisions on the ground that the statutory remission procedure in those cases was discretionary. But the discretionary nature of the remission procedure played no role in the court's constitutional analysis. Culley and Sutton also try to characterize the language in those decisions as dicta. We disagree? The court ruled for the government on the ground that a timely forfeiture proceeding provides the post-seizure hearing required by due process in civil forfeiture cases. No separate preliminary hearing is constitutionally required. Culley and Sutton also contend that a different precedent should be the test for deciding when additional process is due and that, under that precedent, a preliminary hearing would be required in civil forfeiture cases. But this court decided those earlier cases after the precedent. Yet in those two cases, the court did not apply that test. In any event, there is no good reason to think that the balancing test would yield a different result here. A timely forfeiture hearing protects the interests of both the claimant and the government. An additional preliminary hearing of the kind sought by petitioners would interfere with the government's important law enforcement activities in the period after the seizure and before the forfeiture hearing. In arguing that the Constitution requires a preliminary hearing, Culley and Sutton also point to this court's decisions in the criminal context. That analogy is flawed. The Constitution requires that any person who is arrested without a warrant be brought before a neutral magistrate within 48 hours, absent extraordinary circumstances. But those hearings are not adversarial, and they address only whether probable cause supports the arrestee's detention. Here, Culley and Sutton do not request a mere probable cause hearing. Rather, they argue that the immediate seizure of property requires adversarial preliminary hearings, and they assert that those hearings must address their affirmative defense of innocent ownership. Culley and Sutton therefore contend that the Due Process Clause requires more extensive preliminary procedures for the temporary retention of property than for the temporary restraint of persons. The Due Process Clause does not demand that incongruity. Finally, the dissent here relies heavily on a previous decision. There, this court held that the government must ordinarily provide notice and a hearing before seizing real property that is subject to civil forfeiture. The court emphasized that real property, unlike personal property, cannot be moved or concealed during the forfeiture process. That case did not purport to disturb the rule that the government may seize and retain personal property, such as a car, that is subject to civil forfeiture when the property otherwise could be removed, destroyed, or concealed before a forfeiture hearing. And, more to the point, that case did not alter the holding that a timely forfeiture hearing provides the process that is due following the immediate seizure of personal property. In sum, it has been held that a timely forfeiture hearing satisfies due process in civil forfeiture cases, and previous decisions specified the standard for when forfeiture hearings are timely. Culley and Sutton have not asked the court to discard those precedents in this case, and those precedents make clear that due process does not require a separate preliminary hearing before the forfeiture hearing. Historical practice reinforces the holdings that due process does not require preliminary hearings in civil forfeiture cases. Since the founding era, statutes have authorized the government to seize personal property and hold it pending a forfeiture hearing, without a separate preliminary hearing. For example, the first federal forfeiture law authorized the civil forfeiture of ships, goods, and merchandise involved in suspected violations of the customs laws. The Act's forfeiture process began with the seizure of property by a customs collector. The collector then filed a forfeiture action, which a court would hear and determine according to law. While that action was pending, the seized property could remain in the custody of the collector. A claimant could also recover the property on bond. The Collection Act did not require a separate preliminary hearing before the forfeiture hearing. Rather, the forfeiture trial supplied the opportunity for the property owner to challenge the collector's case. In 1790 and 1799, Congress revised and reenacted the Collection Act. The revised versions of the Act contained similar forfeiture provisions, and likewise lacked anything resembling a separate preliminary hearing. Many state forfeiture statutes from the founding period similarly did not require a preliminary hearing before the forfeiture hearing. For example, New York customs statute from that era provided that a property owner could recover his seized goods by either prevailing at a forfeiture trial or executing a bond for an appraised amount. The statute did not allow property owners to challenge the validity of the seizure through a separate preliminary hearing or any similar procedure. In addition, when the 14th Amendment was ratified in 1868, Congress did not require preliminary hearings. In 1864, for example, Congress provided that goods seized under a new revenue law should remain in the care and custody of the government until final judgment in a forfeiture trial. Although that revenue law provided for bond, it did not grant property owners a right to preliminary hearings. Similarly, in 1866, Congress required that goods and vessels seized under a new customs law remain in the custody of a customs official pending adjudication by the proper tribunal. Many state forfeiture laws from around the time of the 14th Amendment likewise did not provide for a preliminary hearing. For example, a New Hampshire statute required that a state official detain personal property that was seized for civil forfeiture until the property was legally disposed of through either bond or a forfeiture trial. Likewise, a Vermont statute authorized the seizure of liquor that was intended for sale, required the seizing officer to keep the liquor until final action is had thereon, and limited the conditions in which a claimant could recover the liquor. Petitioners and their amici do not identify any federal or state statutes that, before the late 20th century, required preliminary hearings in civil forfeiture cases. To be sure, some states have recently enacted laws requiring preliminary hearings in civil forfeiture cases, but those recent laws do not support a constitutional mandate for preliminary hearings in every state. In short, both Congress and the states have long authorized law enforcement to seize personal property and hold it until a forfeiture hearing. The absence of separate preliminary hearings in civil forfeiture proceedings, from the founding until the late 20th century, is weighty evidence that due process does not require such hearings. The historical practice in civil forfeiture proceedings thus reinforces that in civil forfeiture cases involving personal property such as cars, the Due Process Clause requires a timely forfeiture hearing but does not require a preliminary hearing. To balance the interests of the government and individuals in civil forfeiture cases involving personal property, the states and Congress have adopted a wide variety of approaches. For example, some states require that the forfeiture hearing occur within a fixed period of time. Others require a jury trial. Still others condition civil forfeiture on a successful criminal prosecution. And a few now require preliminary hearings. Our decision today does not preclude those legislatively prescribed innovations. Rather, our decision simply addresses the baseline protection of the Due Process Clause. In civil forfeiture cases, the Due Process Clause requires a timely forfeiture hearing, but does not require a separate preliminary hearing. We affirm the judgment of the U.S. Court of Appeals for the 11th Circuit. It is so ordered. Justice Gorsuch, with whom Justice Thomas joins, concurring. I agree with the Court that, at a minimum, the Due Process Clause requires a prompt hearing in civil forfeiture cases. I agree that no legal authority presented to us indicates a prompt hearing must necessarily take the form Ms. Culley and Ms. Sutton suppose. I agree too that Matthews v. Eldridge does not teach otherwise. Under its terms, judges balance the private and governmental interests at stake to determine what procedures the government must observe when it seeks to withhold benefits such as welfare or Social Security. That test does not control, and we do not afford any particular solicitude to governmental interests, in cases like this one where the government seeks to deprive an individual of her private property. But if all that leads me to join today's decision, I also agree with the dissent that this case leaves many larger questions unresolved about whether, and to what extent, contemporary civil forfeiture practices can be squared with the Constitution's promise of due process. I write separately to highlight some of them. The facts of this case are worth pausing over because they are typical of many. Halima Culley, a Georgia resident, bought a 2015 Nissan Altima for her son to use while he was away studying at the University of South Alabama. The car belongs to her, and she pays for its registration and insurance. The plan was for her son to bring the car home during the summer for the family to share. But before that could happen, a police officer in Alabama pulled her son over and arrested him for possessing marijuana and drug paraphernalia. The officer also took the car. Eventually, law enforcement officials learned that the Nissan belonged to Ms. Culley, not her son. But instead of returning it, they initiated civil forfeiture proceedings in the hope of keeping the vehicle permanently. It took a lawsuit and a 20-month wait for the car to make its way back to her. For Alabama, this was business as usual. Often, the state's law enforcement agencies may take and keep private property without a warrant or any other form of prior process. Instead, only after taking the property must the agency file a civil forfeiture action in court. Once there, the agency need present only a prima facie case that the property in question represents proceeds traceable to a drug crime or property used to facilitate one. If the agency proves just that much, the burden sometimes shifts to the property's owner to prove she was an innocent owner who did not know about or consent to the conduct that caused the property to be taken. Should the agency prevail in the end, it may keep the property for its own use or sell it and keep the money. Laws like Alabama's exist in many states and at the federal level, but as commonplace as these civil forfeiture laws may be, most are pretty new. As part of the war on drugs, in the 1970s and 1980s, Congress began enacting sweeping new civil forfeiture statutes, allowing the government to seize and keep the proceeds of drug crimes and the personal property used to facilitate them. Since then, the federal government has extended similar civil forfeiture rules to most federal offenses. Today it appears, white-collar and firearms crimes now account for larger shares of all federal forfeitures than drug crimes. Following the federal government's lead, many states have adopted similar laws of their own. These new laws have altered law enforcement practices across the nation in profound ways. My dissenting colleagues catalog a number of examples, but consider just a few here. To secure a criminal penalty like a fine, disgorgement of illegal profits, or restitution, the government must comply with strict procedural rules and prove the defendant's guilt beyond a reasonable doubt. In civil forfeiture, however, the government can simply take the property and later proceed to court to earn the right to keep it under a far more forgiving burden of proof. In part thanks to this asymmetry, civil forfeiture has become a booming business. In 2018, federal forfeitures alone brought in $2.5 billion. Meanwhile, according to some reports, these days up to 80% of civil forfeitures are not accompanied by a criminal conviction. Law enforcement agencies have become increasingly dependent on the money they raise from civil forfeitures. The federal government shares a large portion of what it receives with state and local law enforcement agencies that aid its forfeiture efforts. At one time or another, over 90% of the agencies serving jurisdictions with populations above 250,000 have participated in this equitable sharing scheme. And it seems that when local law enforcement budgets tighten, forfeiture activity often increases. Not only do law enforcement agencies have strong financial incentives to pursue forfeitures, those incentives also appear to influence how they conduct them. Some agencies, for example, reportedly place special emphasis on seizing low-value items and relatively small amounts of cash, hopeful their actions won't be contested because the cost of litigating to retrieve the property may cost more than the value of the property itself. Other agencies seem to prioritize seizures they can monetize rather than those they cannot, posing for example as drug dealers rather than buyers, so they can seize the buyer's cash rather than illicit drugs that hold no value for law enforcement. Delay can work to these agencies' advantage as well. Faced with the prospect of waiting months or years to secure the return of a car or some other valuable piece of property, they need to work and live. Even innocent owners sometimes settle by paying a fee to get it back. Contributing to the inducement to settle is how little proof the agencies must produce to win forfeiture. The cost of litigation, and the need to appear in court, sometimes, as Ms. Culley learned, in a different state. And if these tactics and burdens work against all affected individuals, can it be any surprise the poor and other groups least able to defend their interests often suffer most? To my mind, the due process questions surrounding these relatively new civil forfeiture practices are many. Start with the most fundamental one. The Fifth and 14th Amendments guarantee that no government in this country may take life, liberty, or property without due process of law. As originally understood, this promise usually meant that a government seeking to deprive an individual of her property could do so only after a trial before a jury in which it, not the individual, bore the burden of proof. So how is it that, in civil forfeiture, the government may confiscate property first and provide process later? The answer, if there is one, turns on history. If, as a rule, the due process clauses require governments to conduct a trial before taking property, some exceptions are just as deeply rooted. And for just that reason, these exceptions too may be consistent with the original meaning of the Fifth and 14th Amendments. As this court has put it, a process of law must be taken to be due process of law if it enjoys the sanction of settled usage both in England and in this country. But can contemporary civil forfeiture practices boast that kind of pedigree? This court noted that English and early American admiralty laws allowed the government to seize a vessel involved in piratical or other maritime offenses, and later initiate post-deprivation civil forfeiture proceedings. The court observed that similar legal rules existed for cases involving objects used in violation of the customs and revenue laws. After emphasizing the existence of those traditions, the court proceeded to uphold the civil forfeiture of a boat. Later, and proceeding on much the same basis, the court approved various aspects of civil forfeiture practice in the context of customs enforcement actions. These historical traditions suggest that post-deprivation civil forfeiture processes in the discrete arenas of admiralty, customs, and revenue law may satisfy the Constitution. But as the court stressed, the general rule remains that the government cannot seize a person's property without a prior judicial determination that the seizure is justified. And it is far from clear to me whether the post-deprivation practices historically tolerated inside the admiralty, customs, and revenue contexts enjoy the sanction of settled usage outside them. The reasons for the law's traditionally permissive attitude towards civil forfeiture in those three contexts may merit exploration too. From a brief look, it seems they were sometimes justified for reasons particular to their fields. In the early Republic, for example, once a ship involved in violations of the nation's piracy or customs laws slipped port for a foreign destination, American courts often could not exercise jurisdiction over it or its crew, let alone its owners. In many instances, the law recognized that seizing the ship, subject to post-deprivation procedures, represented the only adequate means of suppressing the offense or wrong, or ensuring an indemnity to the injured party. But if history sanctions that line of thinking, it's hard not to wonder, how does any of that support the use of civil forfeiture in so many cases today, where the government can secure personal jurisdiction over the wrongdoer, and where seizing his property is not the only adequate means of addressing his offense? Even supposing some modern civil forfeiture regimes are able to claim the sanction of history, I wonder whether all their particulars might. In the past, it seems the government could confiscate only certain classes of property. So, for example, admiralty statutes regularly authorize the government to seize and pursue the civil forfeiture of the instruments of the offense, say a ship used to engage in piracy. But statutes like that did not necessarily mean forfeiture extended to the vessel's cargo, and courts were loath to assume they did. Today, by contrast, civil forfeiture statutes routinely permit governments to confiscate not just instruments used in an offense, but other facilitating property as well. And if that difference seems a small one, it is anything but. It is the difference between being able to confiscate the materials and equipment used to produce an illicit drug, and being able to confiscate someone's car after he used it as the site to conduct a single drug transaction as either buyer or seller. Even in the areas where the law tolerated civil forfeiture, earlier generations tempered some of its harshest features. Courts, for example, ordinarily entertained overwhelming necessity as a defense to the violation of revenue laws that might otherwise justify forfeiture. Some statutes permitted the owner to avoid forfeiture by proving that the violation proceeded from accident or mistake. Others empowered the Treasury Secretary himself to afford the same remedy. And evidence suggests officials were exceedingly liberal in their use of the power, granting relief in the overwhelming majority of cases presented to them. These days, meanwhile, many civil forfeiture statutes lack some or all of these mitigating features. I acknowledge that this court has suggested an innocent owner defense is not always constitutionally required. But even putting that debate aside, what of early forfeiture's other ameliorative attributes? It appears, too, that time was often of the essence in traditional civil forfeiture practice. For example, an early federal statute permitting forfeiture for non-payment of internal duties enjoined the collector to cause suits for forfeiture to be commenced without delay and prosecuted to effect. In an admiralty case, Chief Justice Marshall remarked, if the seizing officer should refuse to institute proceedings to ascertain the forfeiture, the district court may, upon the application of the aggrieved party, compel the officer to proceed to adjudication or to abandon the seizure. And in many instances, owners could recover their property while the forfeiture proceedings were ongoing by posting a bond. It's another feature of historic practice that raises questions about current ones, in which even innocent owners can wait for months or years for forfeiture proceedings to play out. Why does a nation so jealous of its liberties tolerate expansive new civil forfeiture practices that have led to egregious and well-chronicled abuses? Perhaps it has something to do with the relative lack of power of those on whom the system preys. Perhaps government agencies' increasing dependence on forfeiture as a source of revenue is an important piece of the puzzle. But maybe, too, part of the reason lies closer to home. In this nation, the right to a jury trial before the government may take life, liberty, or property has always been the rule. Yes, some exceptions exist, but perhaps it is past time for this court to examine more fully whether and to what degree contemporary civil forfeiture practices align with that rule and those exceptions. Really, it's hard not to wonder whether some current civil forfeiture practices represent much less than a revival of the archaic common law deodand. The deodand required the forfeiture of any object responsible for a death, say a knife, cart, or horse, to the crown. Today, the idea seems much the same even if the practice now sweeps more broadly, requiring almost any object involved in almost any serious offense to be surrendered to the government in amends. The hardships deodands often imposed seem more than faintly familiar too. Deodands required forfeiture regardless of the fault of the owner, himself sometimes the deceased. Not infrequently, the practice left impoverished families without the means to support themselves, faced not only with the loss of a loved one, but also with the loss of a horse or perhaps a cart essential to their livelihoods. Sometimes grieving families could persuade authorities or juries to forego a deodand, but often not, and generally the burden to avoid a deodand was on them. As time went on too, curiously familiar financial incentives wormed their way into the system. Originally, the crown was supposed to pass the deodand, literally a thing given to God, onto the church as an expiation for the soul of the deceased. Over time though, the crown increasingly chose instead to sell off its rights to deodands to local lords and others. These recipients inevitably wound up with a strong interest in the perpetuation of the enterprise. Ultimately, the deodand's appeal faded in England, and this court has held that it did not become part of the common law tradition of this country. But has something not wholly unlike it gradually re-emerged in our own lifetimes? In asking the questions I do today, I do not profess a comprehensive list, let alone any firm answers. Nor does the way the parties have chosen to litigate this case give cause to supply them. But in future cases, with the benefit of full briefing, I hope we might begin the task of assessing how well the profound changes in civil forfeiture practices we have witnessed in recent decades comport with the Constitution's enduring guarantee that no person shall be deprived of life, liberty, or property without due process of law. Justice Sotomayor, with whom Justice Kagan and Justice Jackson join, dissenting. A police officer can seize your car if he claims it is connected to a crime committed by someone else. The police department can then keep the car for months or even years, until the state ultimately seeks ownership of it through civil forfeiture. In most states, the resulting proceeds from the car's sale go to the police department's budget. Petitioners claim that the Due Process Clause requires a prompt, post-seizure opportunity for innocent car owners to argue to a judge why they should retain their cars, pending that final forfeiture determination. When an officer has a financial incentive to hold onto a car and an owner pleads innocence, they argue, a retention hearing at least ensures that the officer has probable cause to connect the owner and the car to a crime. Today, the court holds that the Due Process Clause never requires that minimal safeguard. In doing so, it sweeps far more broadly than the narrow question presented, and hamstrings lower courts from addressing myriad abuses of the civil forfeiture system. Because I would have decided only which due process test governs whether a retention hearing is required, and left it to the lower courts to apply that test to different civil forfeiture schemes, I respectfully dissent. Civil forfeiture occupies a murky space between criminal forfeiture and ordinary government deprivations of property. Criminal forfeiture is part of a defendant's criminal punishment. The government must therefore proceed against the person in personam to obtain someone's property via criminal forfeiture, which generally requires notice of intent to forfeit the property in a criminal indictment and full criminal procedural protections for the defendant. At the outset, the government must typically prove that it has probable cause to seize the person for a specific crime, and therefore to hold any property related to that crime. Outside the criminal context, the government usually must provide a hearing before depriving someone of essential property. In some circumstances, the necessity of quick action by the state may prevent a pre-deprivation hearing. Then, however, the government must make available some meaningful means by which to assess the propriety of the state's action at some time after the initial seizure, to satisfy the requirements of procedural due process. Civil forfeiture is a hybrid, where prosecutors proceed against any property, in rem, they believe is connected to a crime, even when the owner is innocent. Unlike criminal forfeiture, civil forfeiture proceedings are untethered from any criminal prosecution. In fact, as many as 80% of civil forfeitures are not accompanied by any ultimate criminal conviction. Civil forfeiture is unnecessary where the government pursues criminal forfeiture in an indictment and sustains a conviction. Only if an officer seizes property that he believes is connected to a crime, but does not belong to a defendant charged with that crime, must prosecutors bring civil forfeiture proceedings outside a criminal case. Even when the state abandons the prosecution that formed the basis for the seizure, an innocent property owner can be left in civil forfeiture proceedings trying to get her property back. The federal government, states, and localities set their own rules for civil forfeiture, subject only to the limits of the Due Process Clause. This lack of standardized procedural safeguards makes civil forfeiture vulnerable to abuse. In 32 states and the federal system, when law enforcement agencies forfeit property, the proceeds go to their own budgets. As a result, police agencies often have a financial incentive to seize as many cars as possible and try to retain them. The forfeiture revenue is not a supplement. Many police agencies in fact depend on cash flow from forfeitures for their budgets. These cash incentives not only encourage counties to create labyrinthine processes for retrieving property, in the hopes that innocent owners will abandon attempts at recovery, they also influence which laws police enforce, how they enforce them, and who they enforce them against. Police officers have an incentive to enforce the law in a way that leads to the recovery of fungible property, like cash or cars. For example, officers might pose as drug dealers instead of buyers in a sting operation, because it allows police to seize a buyer's cash rather than a seller's drugs, which have no legal value to the seizing agency. Similarly, police officers might target low-level drug possession in cars instead of drug transactions on the street, so that they can seize the vehicle. In this case, police officers pulled over petitioner Halima Tarifa Culley's college-age son while he was driving a car registered to her, charged him with possession of marijuana, and seized the car. A police officer cannot sell recovered marijuana, and a prosecutor's office does not ordinarily pursue low-level marijuana offenses. When a police department can recover the proceeds from a car civilly forfeited in connection to a low-level marijuana offense, however, targeting that offense becomes more appealing. Moreover, officers have a financial incentive to target marginalized groups, such as low-income communities of color, who are less likely to have the resources to challenge the forfeiture in court. One way for law enforcement agencies to generate profits is to target low-income parties who are financially incapable of challenging seizures. A study found that the seizure of non-narcotic property from Black and Hispanic arrestees increases with the size of the budget deficit in states where police departments can retain revenue from seized property. These same groups are often the most burdened by forfeiture, because they are more likely to suffer in their daily lives, while they litigate for the return of a critical item of property, such as a car. For many people, loss of access to a car, even temporarily, is significant. Over 85% of Americans drive to work. Studies have found a link between the inability to drive and the loss of a job. In New Jersey, 42% of people lost their jobs after their driver's license was suspended. Loss of a car not only takes away one's ability to commute but also imposes a barrier to buying necessities, accessing healthcare, and visiting family members, pharmacies, grocery stores, hospitals, and other essential services. Given these burdens, low-income communities are also the most vulnerable to pressure from unchecked prosecutors, who can use coercive civil forfeiture processes to extract settlement money from innocent owners desperate to get their property back. In Detroit, for example, car owners recently alleged that Wayne County seizes vehicles in areas generally associated with crime and holds onto the vehicles and their contents unless the owners pay steep redemption fees, $900 for the first seizure, $1,800 for the second, and $2,700 for the third. If the owner is unwilling or unable to pay this fee, she must either abandon the vehicle or wait for county prosecutors to decide whether to initiate forfeiture proceedings. Before such proceedings are brought, however, the owner allegedly must attend 4 or more pre-trial conferences during regular work hours, during which the owner typically will not get to plead her case to a judge. Instead, prosecutors will attempt to persuade her to pay the redemption fee, towing costs, and storage fees. Missing just one conference allegedly will result in automatic forfeiture and transfer of title to the county. Similarly, in Massachusetts, one investigation found over 500 instances in a single county where law enforcement held property for a decade or more before officials finally commenced forfeiture proceedings. In one instance, prosecutors ran a newspaper notice 4 years after a seizure, at which point the property owner had only 20 days to file a claim to avoid forfeiture. Similar delays have been reported in South Carolina, Oklahoma, and Pennsylvania. In short, law enforcement can seize cars, hold them indefinitely, and then rely on an owner's lack of resources to forfeit those cars to fund agency budgets, all without any initial check by a judge as to whether there is a basis to hold the car in the first place. This court granted certiorari to address which of its tests should govern due process challenges that seek a retention hearing after an officer seizes a car. Now, the court reaches far beyond that question to hold that people whose cars are seized by the police never have a due process right to a retention hearing. The court arrives at this conclusion by relying on two customs cases from the 1980s and historical practice that purportedly reinforces their application. Its reasoning is deeply flawed. The majority says that this court's decisions in $8,850 and von Neumann resolve this case. These cases, however, have little to say about what due process requires when an innocent owner seeks to retain her car pending an ultimate forfeiture determination in schemes like those described above. Instead, the claimants in this cases argued that the United States Customs Service took too long to resolve forfeiture proceedings against property seized at the border as part of the claimant's own alleged violations of customs law. In United States v. $8,850, a customs inspector seized $8,850 in cash from Mary Josephine Vasquez, who had declared she was carrying less than $5,000. Vasquez was charged with a felony and a misdemeanor, with the indictment seeking forfeiture of the $8,850 as part of the misdemeanor charge. When a jury ultimately convicted Vasquez of only the felony count, which did not contain the forfeiture allegations, the government finally filed civil forfeiture proceedings against the cash. Vasquez argued only that the government's 18-month delay in filing civil forfeiture proceedings was unconstitutionally long. To evaluate her claim, the court borrowed the Barker v. Wingo multifactor test from the speedy trial context and held that the balance of factors indicated that the government's delay was reasonable in the circumstances. In so holding, the court emphasized that the government had diligently pursued the pending criminal proceedings against Vasquez. Because a conviction on the misdemeanor count could have rendered civil forfeiture unnecessary, the government's delay in filing a civil forfeiture proceeding was understandable. In United States v. von Neumann failed to declare a newly purchased Jaguar Panther car to customs officials when he drove it back to the United States. United States Customs seized the car, and von Neumann filed a petition for administrative remission proceedings the same day. 2 weeks later, he posted a bond and regained possession of the car. 36 days after he filed his remission petition, Customs resolved it by reducing von Neumann's penalty for failure to declare to $3,600. Von Neumann argued that the 36-day delay in responding to his administrative remission petition violated due process. The government responded that due process considerations do not govern the Secretary's disposition of administrative remission petitions. The court agreed with the government. Implicit in this court's discussion of timeliness in $8,850 was the view that the regular civil forfeiture proceeding, without more, provides the post-seizure hearing required by due process to protect von Neumann's property interest in his car. The administrative proceedings did not trigger a separate due process right, the court continued, because they were discretionary and not necessary to a forfeiture determination. The court then declined to address the argument that the remission statute itself creates a property right which cannot be taken away without due process. Even if respondent had such a property right, the court explained, any due process requirement of timely disposition was more than adequately provided here. The court had already noted that his right to a forfeiture proceeding meeting the Barker test satisfies any due process right with respect to the car and the money. Von Neumann had also failed to show what prejudice he suffered from the 36-day delay in the response to his remission petition. The majority takes von Neumann's imprecise categorical language out of this vital context to hold that a timely forfeiture hearing satisfies any due process right with respect to a car that has been seized for civil forfeiture. In doing so, it extends the holdings of both von Neumann and $8,850 to situations neither court contemplated. In both, the government sought to forfeit property tied to the claimant's unlawful conduct. The claimants were not, and did not claim to be, innocent owners of property used for criminal ends without their knowledge. Unlike petitioners here, neither the claimant, in $8,850, nor the claimant in von Neumann had argued that a retention hearing was necessary to test customs justification for seizing their property at the outset. Instead, both argued only that the government took too long to resolve their proceedings, in $8,850 through a statutory process, and in von Neumann through a discretionary administrative one. The majority's reading here improperly resolves a constitutional challenge that the court in those cases had no cause or reason to address. With the sole exception of the 11th Circuit, every court of appeals has rejected von Neumann's application to state and county civil forfeiture schemes concerning claimants' cars. Indeed, this court has distinguished von Neumann in contexts where officers have a financial incentive to seize property, and owners may assert innocence of the underlying crime as a defense. In United States v. James Daniel Good real property, for example, this court held that the government must conduct a pre-deprivation hearing before it seizes real property connected to criminal conduct through civil forfeiture. 4 years after James Daniel Good pleaded guilty to state charges based on drugs found in his home, the federal government filed civil forfeiture proceedings against his home. Even though Good did not assert innocence, the court emphasized that proceedings without a pre-deprivation hearing created an unacceptable risk of error for property owners asserting an innocent owner defense, because waiting until the final forfeiture hearing would not cure the temporary deprivation that an earlier hearing might have prevented. Crucial to the court's reasoning was the fact that the government has a direct pecuniary interest in the outcome of the proceeding when it is entitled to forfeit the property. This reasoning applies directly to due process challenges, where police seize the cars of innocent owners and use forfeiture proceeds to fund department budgets. The narrow holdings is $8,850, and von Neumann should not determine the due process claims of every claimant deprived of access to her car by state prosecutors on untested grounds for months or years. The majority's categorical rule that due process never requires a retention hearing also cannot be squared with the context-specific analysis that this court's due process doctrine requires. Due process, unlike some legal rules, is not a technical conception with a fixed content unrelated to time, place, and circumstances. Due process is flexible and calls for such procedural protections as the particular situation demands. The court granted this case to resolve which of two flexible due process tests should govern, not to resolve whether due process ever requires a retention hearing in civil forfeiture schemes. That difference is important. An appropriately context-specific due process test should not always yield the same result when applied to different schemes. Of the 6 circuits that have applied the test from Matthews v. Eldridge to various civil forfeiture schemes, 3 have held that due process requires a retention hearing, and 3 have held that it does not. That result is consistent with the flexible dictates of any due process test, which should take into account all the component parts of an individual scheme. For instance, petitioners had the right to post a bond to get back their vehicles, the right to move for summary judgment in the forfeiture proceeding itself, and the opportunity to seek separate relief under the Alabama Rules of Criminal Procedure for an illegal seizure. The adequacy of those alternative procedures was never briefed below because the only question was which test should apply. By contrast, the New York City scheme that the Second Circuit concluded violated due process lacked all of those procedures. Differences in the adequacy of available procedures can and should result in different due process outcomes. Instead of answering the question presented and then remanding to the lower court to apply the appropriate test, the majority instead holds that due process never requires a retention hearing. The majority acknowledges that the states and Congress have adopted a wide variety of approaches, yet it prescribes a categorical constitutional rule for all of them. The court today hamstrings federal courts from conducting a context-specific analysis in civil forfeiture schemes that are less generous than the one here. The majority's holding relates only to retention hearings. It does not foreclose other potential due process challenges to civil forfeiture proceedings. People who have their property seized by police remain free to challenge other abuses in the civil forfeiture system. For instance, such claimants could challenge notice of a forfeiture posted only in a newspaper, the lack of a neutral adjudicator at an initial hearing, or the standard of proof necessary to seize a car. Lower courts remain free to apply Matthews to those claims. Due process also still requires a timely post-seizure forfeiture hearing, so claimants may continue to challenge unreasonable delays. The abuses of many civil forfeiture systems are well documented. I commend states or localities that have adopted retention hearings as a way of guarding against those abuses. Other states and localities should not view today's decision as precluding them from following suit and adopting similar measures. The majority today holds that due process never requires the minimal check of a retention hearing before a police officer deprives an innocent owner of her car for months or years. Given the diverse schemes adopted by states, some with adequate safeguards and some without, the court should have just answered the question presented. Instead, it announces a universal rule for all schemes, without heeding the dictates of this court's due process precedents that require a scheme-specific analysis. Because I instead would have answered the question presented and left lower courts the flexibility to apply the appropriate test in these myriad circumstances, I respectfully dissent. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.